Hey, Mallory, welcome back. Today, we're taking a deep dive into LASA consortium claims in Washington State with a focus on how to litigate them effectively. So, for those who don't know that are listening, a LASA consortium claim is a claim that seeks compensation not for the injured person, but rather for their spouse. And it's meant to compensate the uninjured spouse for the losses they experience due to the injuries or impairments that their partner has suffered. So let's start by talking about the legal framework for this type of claim.
Yeah, so in Washington, loss of consortium is a separate, not a derivative cause of action from the injury claim. What that means is a derivative claim is one that exists only because another person has a cause of action, right? So if that applied to loss of consortium, that would mean that the uninjured spouse would only have a claim based on the injured spouse's claim, right? And if that claim failed for any reason, then the uninjured spouse's claim would not be able to succeed. Now, it does depend in some ways on the underlying claim, right? But it is its own independent claim, which means it accrues separately from the underlying claim. So, a great example to explain this, the way that this works, is the Washington Supreme Court case Green v. APC. It's an asbestos case.
Yeah. Well, that case arose from asbestos exposure, which led to serious illness. And the plaintiff's spouse asserted a loss of consortium claim based on the fact that the disease really affected their marital relationship. And before I go on, just to explain a little bit more about loss of consortium, I mean, it originated as just a loss of companionship, but it's expanded beyond that to include more than just companionship. And we'll go through that a little bit more later. But in this particular case, so green, often cited in toxic tort contexts, but it's reinforced Washington's recognition of loss of consortium as a protected relational interest and not merely a claim for loss of household services. So the court acknowledged that consortium includes emotional and components, and it goes beyond just economic contributions. It also reinforced that a spouse's consortium claim depends on the viability of the injured party's underlying tort claim, which is what you were talking about earlier.
Right, and it depends on the viability of that claim, but in this case, the court also stated that it can have a separate, the statute of limitations different for each of these claims. And so in that case, the spouse entered this marriage without knowledge of the person's injury. And so even though for the wife, the injury happened before the marriage and she potentially should have known about it before the marriage, and so her claim might have failed. They did send it back down for their factual findings, but even though that claim might have failed, there still is a separate claim for the husband in that case. They said his injury might have started at a different time, right? Because when he should have known about the injury was different. So it depends on it, but it is a separate and independent claim.
Yeah, and I think a good way to think about it is if the injured party's claim fails on the merits, like because there was no negligence or because they couldn't meet their burden of proof, then the loss of consortium claim also fails. But in this particular case, the Green case, why they distinguished it from just your general derivative claim is because they were saying that in that case, the underlying claim could win on the merits. It was procedurally barred because of the statute of limitations. And the derivative claim, or in this case, it's now an independent claim, that gets confusing. But the spouse's claim, the reason why that did not fail was because you had talked about this earlier. It underlying claim failed procedurally and not substantively.
Right. And so
Um,
there was still a factual dispute that the trial court needed to figure out about whether the negligence actually happened and was caused by the defendant, because that
Yeah.
would allow the spouse's claim to move forward. Yeah.
Yeah. And another twist, and this is a practice twist to all of this, is that it is considered a derivative claim when it applies to insurance limits. So if the insurance policy is a $100,000 policy, well, it's not considered an independent claim. So you don't get, if it's a 100, 300 policy, you don't get to make a claim for the injured person and then a separate claim for the spouse so that you could access both $100,000 policies. You can only access the one $100,000 policy. So,
Right. That policy limit applies to both parties that were injured in the same incident. Yeah.
yeah.
And
Okay, and then there's another case, Lund v. Keppel, and this case arose after a woman was seriously injured due to an alleged medical negligence case, and her husband brought a claim for loss of consortium based on the impact her injuries had on their marital relationship. And the underlying dispute required that the court address whether and how Washington law recognizes a spouse's independent right to recover for those marital losses.
so this case is really important for what you were talking about earlier, too. It affirmed that this claim is an independent claim. The spouse has an independent right to recover for loss of consortium. And also that this claim isn't just about a loss of companionship, but it's about affection, emotional support. In this case, they discussed sexual relations being lost, right? So there's a huge amount of things that go into this claim. And it did also affirm that it remains dependent on the underlying claim by the spouse. And so if there's comparative fault on the part of injured spouse, then that does apply to the recovery for loss of consortium claim for the uninjured spouse as well.
Yeah, and that's an important note that if you have a cause of action and you're comparatively found to be at fault 50%, then your spouse only gets 50% of his or her recovery as well. So
another way where it is sort of a derivative claim, even though the court has held that it's independent and in some ways.
yeah. And so when you are filing the lawsuit, if you're a lawyer, you always want to plead loss of consortium as a separate cause of action and name the spouse as a separate plaintiff.
Yeah, really important. Another important and foundational case in this area of law is Ueland v. Reynolds Metals Co. This is a 1984 case that talks about loss of consortium. In this case, a man was catastrophically injured in an industrial accident. And this case involved a minor child, so a slightly different type of relationship, right? Parent-child relationship. And so in this case, the minor child was seeking damages for loss of parental consortium because of the severe impact that his father's injury had on their relationship. And so this case required the Supreme Court of Washington to decide whether this child could recover for the loss of their parents' love, care, companionship, guidance when the parent survived the injury but was seriously injured. And so here the court acknowledged that children do suffer relational harm when a parent's ability to love and provide guidance and companionship is substantially impaired by an injury. The court did emphasize, however, that this is only available for really catastrophic injuries. So this is true even for spouses, that it has to be a pretty significant injury for there to be a loss of consortium, but particularly for this case where there's a child involved, the court emphasized that this is not available for minor or temporary injuries.
Yeah, and you could see how this could really affect their person's childhood, because if their father played sports with them and then could no longer run and throw a ball, couldn't do that anymore, I mean, that would be a huge loss of relationship, that you would be connecting with your mother or father and couldn't connect in that way anymore. So it could be a significant damage. And then as it applies to just spouses, it doesn't necessarily need to be a major injury in order for you to claim loss of consortium. I mean, you can claim it pretty much anytime you feel that the injury has affected your relationship with your spouse. So, and one of the things that's uncomfortable to talk about, but does get talked about in depositions and sometimes in arbitration, sometimes in trial is the sexual relationship part. And I mean, if you were having normal sexual relations and then because of an injury, and not even necessarily that the injury prevents you from doing it, but maybe you're just no longer in the mood anymore because you're in pain or you're dealing with treatment or you're stressed out or whatever. I mean, all those things affect your relationship. And then if you're not having intimacy anymore, then maybe you're not communicating as well. And so all sorts of things happen a relationship when you have an injured person who's in pain all the time and sometimes is in a depressive state because of it.
Yeah, absolutely. And I think there are some strategic decision making that needs to be happening when you're making these kinds of claims. I think particularly when there's a child involved, if there's a huge catastrophic injury and there's a minor child involved, it's important to consider whether there might be a claim there. You have to also consider that there's the proper procedural posture for a minor plaintiff to be involved, that you have to consider that you're increasing your exposure for discovery when you open up that question into what that parent-child relationship looks like. That's true for spousal relationship too. So anytime you're bringing these kinds of claims, it's a strategic decision. Another aspect of that is something that you mentioned, Rick, which is policy limits, right? If there's a policy limit, you have to consider sort of the value that you could get out of that type of claim versus the complexity of bringing it and whether it might bring to light something about the marriage that could otherwise make your plaintiff look less credible or something like that. So all of those are things that you need to consider.
Yeah, it's something that
Factors.
you weigh. I
Yeah.
mean, and here's the other thing about loss of consortium that I've noticed in practice. Pleading it and bringing it is one thing, but when you're getting arbitration is one thing altogether as well, and mediation, you can use it as leverage in negotiation. But when you're going to a jury, if you're bringing a very weak loss of consortium claim, you may lose credibility with the jury because they may think, oh, these people are just trying to get as much as they can out of this claim. And it doesn't, that affects credibility and it could affect the underlying claim as well. I know we do some jury consultant stuff as well as e-juries. And there are times when we bring a loss of consortium claim in an e-jury and the e-jury hates it. They just hate it because you're already asking for a bunch of money on the underlying claim. Now you want your spouse to have a bunch of money too for this injury. So you got to be careful about over.
Yeah, you want to be authentic, right? You want to think
Yeah.
about how this actually impacts the relationship. And that can happen in a lot of ways. You can dig really deep with someone and figure out how it's affecting the relationship, but it has to be real. It has to be authentic. And I think that's also why it's important to consider the severity of the injury, right? How much is this injury really affecting the relationship specifically and the spouse and how they relate to this person?
Yeah.
Yeah. So, Rick, do you have some practice tips for attorneys who are bringing these kinds of claims in terms of sort of fact gathering and presenting this claim?
Yeah, I mean, some of the questions that you can ask the spouse, what did the weekends look like prior to the injury? Who handled the parenting responsibilities before and after? What hobbies or travel did you do together before, and did that change afterwards? And was there any emotional changes or any physical changes? Those are all questions that you want to explore prior to actually going into a deposition with the loss of consortium claim. So having concrete examples is really good. The before and after storytelling, of course, which is why you're asking those questions. And then when you're preparing your client for deposition, you need to recognize that the defense is going to try to minimize that loss as much as possible. They're going to try to suggest that it's exaggerated and they're going to look into your marital relationship and truly try to find out, hey, is it as good as you claim it to be? And so when we're preparing our clients for deposition, we want to make sure that they're specific. They give actual facts, true situations, and they're not being overly dramatic because that does look bad when you're exaggerating. Letting them know that it's okay to admit that the marriage had some difficulties because all marriages do. And so it's unrealistic to presume that you were in a perfect situation. And yeah, just focusing on those concrete changes that were caused by the injury and maintaining their authenticity, those are the things that are going to move the needle in a deposition and increase the value of the claim.
Yeah, and I think what you said is really important about preparing clients because it is uncomfortable to talk about these things sometimes, right? People might be a little prideful about their marriage suffering, or even talking about how your sexual relations have changed might be
Yeah.
really awkward and uncomfortable. So preparing and having those discussions before you reach the deposition is really important.
Yeah.
Yeah, and
Okay.
I think one last thing that I wanted to consider, just offer and throw out there is how important this claim can be and how it can really add value to a personal injury claim. Because Washington does not have a cap on non-economic damages in personal injury cases, and that includes consortium damages. So understanding when and how to successfully bring these claims can really make a huge difference for your client's recovery.
Yeah, absolutely. Thank you, Mallory.
Thanks.
Okay.